So welcome to the first installment of UNH's virtual lecture series. This is a monthly occurrence that we've just started, and if you can go to the website every month, and you can check out which future lectures are coming up. I'm Professor Ryan Vaca. I'm a faculty member here at UNH, where I focus on intellectual property law, and I'm excited to talk to you tonight about 3D printing and IP. So I want to first kind of go through the outline of what we're going to talk about over the next 20 minutes. The format here is I'll talk for about 20 minutes, and then we'll reserve about 10 minutes for question and answer sessions at the end. If you have questions, feel free to type them in the chat box online, and we'll keep a queue and address them at the end. All right, so where are we going in this lecture tonight? Well, first, what we're going to do is do a brief intro of what is 3D printing. Then talk a little bit about how 3D printing works. Then look at the players in the 3D printing ecosystem. Next, we'll take a look at why 3D printing is revolutionary and why it's beneficial and what problems it poses to certain individuals and companies. Then we're going to move into the intellectual property portion of the chat. We'll give a brief overview of where we're going with IP, and then also start digging into patents and copyrights in particular, and how particular rules in patent law and copyright affect 3D printing. And then finally, we'll take a look at strategies for dealing with the 3D printing threat. I'll briefly conclude, and then we'll turn it over for Q&A. So first off, so what is 3D printing? So 3D printing is really just using a special printer to manufacture products. It's been around for quite a while, but now that the cost of 3D printers is so low, they're becoming more prevalent in homes. You can get one now for a few $100s and up to several $1,000s for more advanced ones. So what can be printed with these 3D printers? So a wide variety of objects. Home products. So for example, if you have a broken coat hook or a cracked light switch plate, you can just print a new one at your house and then install it right away. Toys. You want to print a Barbie? Great. You want to print a Barbie with your head on it? Great. You can do that. Tissues and organs. So you need a new kidney? No problem. We can 3D print one for you. Prosthetic devices are being 3D printed. Food is being printed. If you want a 3D printed steak, delicious. And finally, we've seen videos of apartment buildings being 3D printed. So really quite an astonishing area. So how does 3D printing work? Well, generally, this is somewhat oversimplified, but it should give you the gist of how it works. So what we have CAD files, and these are basically digital diagrams of the product to be printed. This can be acquired these CAD files can be acquired in a variety of ways. You can manually create your own. You could do a 3D scan of a particular product and it would be converted into a CAD file. Or you could just download one from various websites such as Thingiverse. Okay. After you have a CAD file, this is converted to what's commonly known as an STL file, which is basically the computer slicing the CAD file into many, many thin layers. This data is then sent to the 3D printer in your home or perhaps some other location, and then the printer starts building the product layer by layer. At the end, you have your product, or if it's printed somewhere else, then the product is shipped to you. All right, so who are the players in the 3D printing system ecosystem? So we have end users, we have product designers, we have product manufacturers, we have product distributors, we have websites like I mentioned with Thingiverse. We have 3D printer manufacturers as well. So why is 3D printing revolutionary and beneficial for society at large? But also, what's problematic about 3D printing? So for product manufacturers, lots of efficiencies are created, right? We have less waste that's produced. We have less of a need for factory space. The product transportation infrastructure is limited. For consumers and end users, we can have customized products. I mentioned the Barbie with your head on it, but we can imagine lots of situations where consumers want a customized product outside of kind of tchotchkes. And this can lead to additional innovations. For product designers, 3D printing can be really a wonderful tool to engage in easy prototyping and testing of new products. For product distributors, if you have multiple locations, then you can print at a local distribution shop, and which is going to thus reduce the resources spent on further distribution. You don't have to drive it across the product across the country. You can print it at the local shop and then drive it a few miles to the consumer's home or business. For the 3D printing manufacturers, we have new markets for product sales. Websites, of course, there's a new market for hosting designs, printing on demand, advertising revenue can be generated. And if we look at just society as a whole, we will have better and cheaper products. End users oftentimes make some of the most useful innovations, and 3D printing may result in an explosion of innovation, very similar to what we've seen with the ease of making creative content with the introduction of cheap digital equipment. But what's the concern? So the concern is that product manufacturers, designers, distributors, they're concerned about harm to their market, right? Lost sales because others can copy or modify or print their products without them. We can essentially eliminate the middleman. Okay. So how does IP fit into this story? So IP is the legal protection given to different types of information. So it includes patents, copyrights, trademarks, trade secrets. And our focus tonight really is going to be on patents and copyrights. Okay. So patents, in short, protect new, non-obvious, and useful inventions. So think of new products and new processes. Copyrights, on the other hand, protect creative expressions, books, statues, painting, software, stuff like that. Now, if somebody has a patent or a copyright, they're able to exclude others from doing a variety of things, including reproducing what's protected. But if there is no IP protection on a product, then it's generally free for others to copy. And the point of patents and copyrights is to encourage innovation and creativity. If others can immediately use and copy a new invention or new expression, then the original creator might not create in the first place because they'll have sunk the time and the effort into creating it, but they're not going to reap the financial rewards. They might not be able to recoup their initial cost. So let's talk a little bit about patents and 3D printing. So patent protection might provide a tool for product designers and manufacturers to stop some 3D printing activities, but it may be a fairly weak tool. So the Patent Act prohibits the making, using, selling, and offering to sell the patented product. And in addition, it also prohibits others from inducing infringement, which is sort of like aiding and abetting. The Patent Act also prohibits one from supplying a component of a patented invention to somebody who makes, uses, or sells the entire patented product. Now, on their face, these sound like they could be very useful tools. So for example, if you have a patent on a particular product, then you could stop someone from 3D printing, making the product, or stop them from using it once it's been printed. Or maybe you try to shut down the websites that are distributing the CAD files. But there are some nuances in patent law that make some of the rules inapplicable to some of the 3D printing activities, or there's some considerations that make legally viable options really impractical. Okay. So some of the legal hurdles in patent law are, using CAD files is not the same thing as using the patented product, because the courts have held that to use a product means to have the product perform its usual function or service. So if you have a CAD file, this software that is essentially a digital diagram, the CAD files don't actually perform the function, right? If you have a patent on a shovel, then the CAD file of the shovel doesn't actually scoop dirt, right? Selling and offering to sell CAD files also isn't the same thing as offering and selling the patented invention, although there is some uncertainty about that in the case law. And for those who distribute CAD files, maybe they're inducing others to infringe. Inducement requires a subjective belief of high probability of infringement and also taking deliberate action to avoid learning of the infringement. There might be some room here for liability, but satisfying these requirements are going to be challenging given the way that many CAD file distributors are set up. Now, to the extent that someone is printing the patented product, they're certainly making the product. And if they use it afterwards, there's a very strong case of infringing use. And if they sell the product to somebody else, then we clearly have an infringing sale. But the hurdle here is more of a practical one than a legal one. So if I'm at my home and I'm printing a single or perhaps a few patented products for my personal use, or maybe I'm giving them to friends and family, how is the patentee going to know about this? It's very difficult to police this type of conduct. Widespread sales are easier to detect. It's still difficult, though. But remember that one of the benefits of 3D printing is that it puts the power of manufacturing in the hands of the end user. So distributors aren't necessary. So the number of detectable infringers is going to be quite small and insignificant. So patent law might be a weak tool. But what about copyrights? Right. Might copyright law be a better tool? So some of the issues from patent law, policing difficulties, inefficient enforcement, this exists in copyright law as well, but there are some unique concerns specifically tied to copyright. So one is the copyrightability of particular products. So although the standard for obtaining a copyright is easier than for obtaining a patent, there are some limitations. And the main one that I want to discuss here very briefly is functionality. Okay. So for products, whether they're 3D printed or not, their useful features are not protectable. So for example, using the shovel example again, a shovel would not be copyrightable because it serves the function of being used to scoop dirt. And to the extent that products are not merely used to be displayed, no copyright protection is going to exist. Now that said, if there are designs that are incorporated into the useful product, the Supreme Court has recently held that these designs might be entitled to copyright protection to the extent that they're separable from the useful article. So if we have, let's say, a flower design that's part of the shovel handle, or it's maybe it's on the blade itself, then this would probably be copyrightable. This would be protectable. And if these copyrightable aspects were copied in the 3D printing process, then we might have infringement. So assuming that we have a copyrightable work, then the next thing we have to look at is enforcement issues. Okay. So when we're thinking about CAD files and distribution and use on the internet, it might be helpful to think about the structure of the online ecosystem. So I've got on the screen here, I've got this inverted pyramid. Right? Now, for copyright owners dealing with 3D printing challenges, there's a variety of targets. Right? From the bottom, we have the backbone providers that allow everyone to have access to the internet. In the middle, we have hardware manufacturers, internet service providers, websites, software vendors who provide a service or a product that may enable infringement. And then at the top, we have the end users, you and me. So there are challenges at each level. Right? So if we attack the backbone providers, essentially killing the internet, this is a really bad idea. Right? It would certainly solve the 3D printing infringement problem, but I don't think anybody's actually in favor of this. Right? If we get rid of the internet, then we won't have any problems with people infringing on the internet. We'll have all sorts of other problems. Attacking the middle layers is difficult as well. So there are rules in copyright law that prohibit product manufacturers, such as software companies or 3D printer manufacturers, from being liable when their product can be used for substantial non-infringing purposes. And so although 3D printers can be used to infringe someone's copyright, we're not going to hold the 3D printer manufacturer liable because there are plenty of non-infringing uses for the printers as well. You want to design your own product. You want to copy something that's in the public domain. That's no problem at all. Those are non-infringing uses, and so we don't want to destroy the 3D printer manufacturing industry because there's some infringement that takes place. There are also special rules for websites that host user-generated content, which limits their liability. And these rules, they do allow copyright owners to notify the websites of infringing content, such as infringing CAD files, and this might result in the infringing files being removed. But the burden is on the copyright owner to be able to identify these files and then make the request for their removal. All right, so that's the middle layer. And then we have this top layer with end users. And going after end users, it might be the easiest in terms of legal barriers. But the obvious problem here is really with scalability, similar to what we saw with patents. Trying to identify, locate, and pursue many individuals is a time-consuming process, expensive process, and it may ultimately have very little impact unless it's done at a massive scale. Okay. So we're running a little bit out of time, so I want to talk for a bit about the strategies for dealing with the threat of 3D printing. So if you have any questions about the specific prohibitions or perhaps defenses in copyright law, I'd be happy to chat about them in the Q&A session at the end. But for now, I want to talk about some of these strategies for how to deal with the threat of 3D printing. Okay. So one option that content owners may have is litigation, right? The problem, of course, is the high cost and uncertain results. The music industry has some experience with this. So if you may recall, in the early to mid 2000s, there was lots of copying of music that was taking place on file sharing sites like Napster and Grokster and Kazaa. And the music industry's approach, it was twofold. One is that they went after end users. They sued thousands and thousands of end users. This generated a tremendous amount of bad press and backlash. It had very little effect on causing consumers to stop making the music available or downloading it or uploading it on these file sharing sites. And eventually, the strategy was abandoned in the early 2010s. The music industry also litigated against these file-sharing companies, and to an extent, they were successful. Right? They shut down Napster, they shut down Grokster and Kazaa. There's a very famous case going up to the Supreme Court involving Grokster. But the problem was that once these websites were shut down, new ones sprung up immediately in their wake. So it's not clear that the litigation approach is the most effective. Another approach that content owners can use is using digital rights management. Right? They can design and implement technological protections that prevent or limit reproduction and distribution of their copyrighted works. Copyright law has some special provisions in it that prohibit circumvention of these types of technical protection measures and also trafficking in circumvention devices. There are some exceptions that the Copyright Office comes up with every few years, and this might work best using these digital rights management measures. These might work best for CAD files, right? If we can put restrictions on being able to copy or reproduce or distribute these types of files, that might stop it from as a technological matter as opposed to a legal matter. And also, we could imagine a situation where we have kind of streaming services. So you're a content owner. You have a particular product that you manufacture and distribute, and your consumers want to be able to 3D print. So maybe one option that you have is you say, great, you can, instead of downloading the file from my company's website, which runs the risk of you being able to make lots of copies of it and share it with your friends, instead what we're going to do is click this button here, and we're going to send the files, not in whole, but we're going to stream them to your 3D printer, and it'll print automatically. You'll get the product, but you're not going to be able to reproduce the files and share the files with others. If they want it, they can come to us and purchase it as well. But the problem with this, or maybe the limitation with it, is it doesn't solve all the problems, right? It's not going to work very well for products that could be scanned, 3D scanned. So, if, for example, I want to sell a bunch of copies of a particular product, I can buy one copy, get a 3D scanning device, which now is available on your cell phone, do the scan, and then I've created my own CAD file. I don't need to get the official one from the manufacturer or designer. So that's another option. And a third option, the final option that we'll talk about, is licensing. So the music and the film industries, they started licensing their work. They started giving permission for others to use their work. So, for example, with iTunes. And this helped them compete with the unauthorized sources. And so maybe product manufacturers, product designers, could do the same thing to develop or control the 3D printing markets. Now you might ask yourself, why would anybody want to buy or license the authorized versions? Can't they just get it for free? Otherwise, they go online, they can download a free copy. Why pay for it? So there might be lots of reasons to receive authentic products. So one could be to meet specifications, right? The company you're working with is working with some third parties that require very precise specifications to be met. Maybe you have more confidence that the original manufacturer will help you meet those. Another option or another consideration might be warranties, right? If you can get a warranty from the original manufacturer on the product, then that's better than not having one at all. Maybe you're willing to pay some amount for that. Similarly, we have repair and technical assistance. So your product breaks down. It might be easy, or you're having some technical problems with it. It might be easy to just contact the manufacturer or producer and say, hey, here's these problems, can you help me along the way, rather than trying to figure it out yourself or working with people who didn't actually design the product in the first place. Another option might be the ability to easily customize the product. With 3D printing, you may have the power yourself to be able to do that using the CAD software, but maybe you don't have the technical expertise to be able to customize it in the way that works best for you, and so the original designer might be in a better position for it, and you might be willing to pay for that. And then finally, it might be a safety concern, right? If you can sort of rest assured that the product that you purchased or the 3D printing CAD file that you received from the original manufacturer, original designer, that that it comes with the instructions of what dyes you should use, or the plastics that you should use, or maybe there's a button that's printed on the device and it's a children's toy. You might take some sort of comfort in knowing that the product is more likely to be safe if it's coming from a reputable source. So those are some of the options that content owners have to protect their works, or at least be able to exploit them in a way that they don't lose out in the way that the music industry did during its approach to file sharing. So the world of 3D printing is really a new and exciting industry that's facing a host of legal and business challenges, including those involving intellectual property. There's lots of unanswered questions. There's lots of questions that haven't even been asked yet because the technology doesn't yet exist. Hopefully you'll be able to participate in this development in this revolutionary industry, and I hope that my comments tonight have helped you think about some of these issues and challenges. So thank you for listening, and I'm happy to answer any questions that you might have. Again, just type them up in the chat box and we'll read them out.
So we do have one question right now. If I had an STL file for, say, a flower vase, is it protectable right now, and how would the creator go about protecting it in 2018?
Right. So if you'd have an STL file. In general, software is copyrightable. That's been the case for quite a while now. And you have this STL file. The software itself might be protectable. Probably would be protectable. The limitations that you might run up against, though, is with a flower pot, for example, that would be a useful article, right? It's serving the purpose of holding the plant up, keeping it upright or whatnot, and so it's serving some function other than to just be displayed itself. And so, to the extent that the actual flower pot would be considered a useful article, then it wouldn't be protectable. And if your STL file was essentially doing an exact, trying to be an exact replica of this useful article of the flower pot, then it might be limited in how much protection you're going to get. Now, that said, if we have if there are design elements in the flower pot itself, so maybe there's a flower or a heart or something on the outside of the flower pot, and that could be copyrightable, very likely would be copyrightable itself, so that the STL file could capture that, it would still be copyrightable, and if anybody were to copy your STL file and it had that minimal amount of creativity, that could be infringement. And if they printed out your flower pot that had a copyrightable design on it, then that could be infringing as well. Good question. That's it. Okay. All right. It doesn't look like we have any more questions at the moment, so we'll go ahead and stop here. Thank you again for listening, and if you have any questions perhaps afterwards, I'm happy to, you can send me an email and I'd be happy to answer them via email. So we look forward to having you participate in these future lecture series, and have a good evening.